Hi, it's attorney Lisa Wentz with Family Matters Law Group, and I wanted to talk about mandatory disclosure. So, mandatory disclosure is the exchange of financial information between two parties in a family law case. Mandatory disclosure is required in any case that has a financial component to it. And for the most part in family law, that is all cases. It's very rare that there is a case that doesn't have a financial component that would not require mandatory disclosure. Mandatory disclosure is governed by a rule that we reference as the Family Law Rule of Procedure 12.285, and it contains a list of documents that have to be provided from one party to another in the context of a divorce or a custody case or a modification, anything, like I said before, that is going to have a financial component. Now, depending on the kind of case, what information is relevant is going to depend. In a paternity case, for example, where custody is the only issue, what we're mostly interested in getting information about is a person's income. Although expenses do come into play, and just because income and expenses are the only two really major topics for purposes of the legal case, it doesn't mean that you're not required to exchange all of the other information. The other information is going to include tax returns, business tax returns, checking account statements, saving account statements, stocks, bonds, certificates, information pertaining to mortgages or purchases of homes. So at the end of the day, all of this information is for the purpose of us assessing what assets exist, what liabilities exist, whether those assets and liabilities are marital or non-marital in the context of a divorce, and determining how much income a person has. So all of this discovery, as we call it, back and forth, has to be exchanged between the two parties. You're required to produce yours, and they are required to produce theirs. We then have an opportunity to review these things. Now, in some cases, we agree to really seriously limit the information because we know from the get-go that it's just not that pertinent or that it's not going to be a major issue in the case. That is taken on a case-by-case basis. The biggest and most unwaivable part of mandatory disclosure is a financial affidavit. The financial affidavit is filed in nearly every family case, and it is where you are swearing on one piece of paper to what assets, liabilities, expenses, income, and information related to other aspects of your financial life exist. So this is a document that gets filled out in the beginning of a case. You are swearing to the truthfulness of the document. It can be more simplified or more complicated depending on how much money you make, and also depending on whether the other side is asking for a more complicated form. One is called a short form, one is called a long form. We usually start with a short form unless a person makes over $50,000, in which case we have to start with the long form. Filling out this financial affidavit, filing a financial affidavit, is not something that's waivable. It's something that's required for us to do. And it is the way that we swear that we have exchanged the accurate information about the finances of a case. If you have more questions about your financial affidavit, about mandatory disclosure, we're happy to have a consultation to discuss this with you. If you're already a client, we're happy to get you in touch with your attorney and set up an appointment to discuss the details, or you can work with the paralegal to start getting this information gathered together for your case.